Finch.
My Lord, turning to the third point of our fourth submission. My learned friend made a point that a trader may not know an individual's subjective motivations. But
Yes.
the fact is that such motivations not being communicated is not relevant nor indeed determinative of the question of whether somebody is a consumer or not. It is entirely common for traders to be entirely unaware of the purpose which a contract is entered into. Take, for example, a queue at the ticket machine at your local train station. The person at the front of the queue may well be a sole trader travelling to London for a business meeting. The next person in line may well be heading into London to meet friends and explore the museums. The first is obviously a business user, the second is obviously a consumer, but the train company is none the wiser. The fact that the motivation can't be known necessarily to the trader is not a reason to deprive an individual of consumer status. Fourth point. In a related fashion, my learned friend relied on section 71 of the CRA, the obligation of the court to consider fairness of terms, and made the point that as a matter of policy, it's important not to take account of subjective motivation because that evidence often won't be before the court exercising its role under section 71. But the answer to that is section 71 subsection 3. We can see that at divider 9 of the authorities bundle, page 97, hard copy, 102 electronic. The obligation on the court under subsection 2 to consider the fairness of the term does not arise by virtue of subsection 3 unless the court considers that it has before it sufficient legal and factual material to enable it to consider the fairness of the term. So the obligation to consider fairness only arises where there's sufficient material before the court in any event.
But that relates to the fairness rather than other elements, doesn't it?
Yes, but my lady, if the court doesn't have sufficient material before it to determine even whether the individual is a consumer, then it flows that it would not have the sufficient material before it to consider whether it was an unfair consumer term. The fifth and final point is that we say the judge did not place significant weight on Mrs. Zhang's subjective motivation. The judge recited the evidence at paragraphs 63 to 72 of his judgment, core bundle divider 5, page 87 and 88. In the interest of time, I won't read it out, but I'm sure the court is well aware of it. There's no reference in those passages to Mrs. Zhang's subjective intention. The focus, when the judge was reciting the evidence, was of Mrs. Zhang's business dealings, or rather lack of business dealings, and the evidence concerning the shareholding. Having considered that evidence and all of the evidence in the round, the judge provides his analysis and conclusion at paragraphs 78 to 85. At paragraph 78, His Lordship first puts aside Mrs. Zhang's shareholding and says, ignoring that for a moment, Mrs. Zhang entered into the personal guarantee for a purpose of a private nature, her marriage. That's the conclusion. And we say that conclusion is not dependent upon Mrs. Zhang's subjective evidence of her intention, rather it is objectively obvious from the key facts. Firstly, guarantees were only sought from Mr. and Mrs. Zhang. For Mr. Zhang, that can of course be explained by him managing and controlling Chongqing and being being a board director, and at the least a large minority shareholder. That's judgment paragraph 64. For Mrs. Zhang, it can only realistically be explained by her marital status. Indeed, my learned friend's argument is that the guarantee was sought because Mrs. Zhang was part of a majority shareholder couple. It was sought from Mrs. Zhang because she was married to Mr. Zhang, who was the largest shareholder. And I won't repeat the submissions I've made already on treating his shareholding as her shareholding. And it's notable that no other minor shareholders provided guarantees. Second, Mrs. Zhang was not involved in Chongsing or the negotiations concerning the subscription agreement or the personal guarantee. You have that at judgment paragraph 83. The first she found out about the subscription agreement and the guarantee was when she was asked to sign the signature page of the guarantee. And as was covered briefly this morning, Mrs. Zhang had a history of signing documents at the request of her husband without taking legal advice or considering the same. That's exactly what she did here. She signed because she was asked to by her husband's personal assistant, not in order to further her trade, business, craft, or profession. Now, we accept, of course, that the judge does make reference to Mrs. Zhang's evidence of her intention at paragraphs 78 and 79 of his judgment. But it's worth noting that this is in response to a tentative argument from Eternity Sky that Mr. and Mrs. Zhang's marriage involved at least as much financial pragmatism as romance. Those passages were not the driver of the judge's conclusion on the purpose Mrs. Zhang had in entering the contract. Finally, our fifth submission, and this comes back to the words wholly or mainly in section 2.3. Even if Mrs. Zhang's shareholding was not negligible, and even if one could describe her as having a functional link to Chongsing, such as to give her a potential business purpose or motive, this was not the reason she entered into the guarantee, and it was certainly not the main or whole reason. This is where those words wholly or mainly start to make a difference. The deliberate insertion of wholly or mainly into the CRA means that even if there was a business motive in conjunction with Mrs. Zhang's personal private marriage motive, Mrs. Zhang will qualify as a consumer unless her business motive dominated, and we say it's clear that it did not. This was the judge's finding at paragraphs 84 and 85. In comparison to her shareholding, Mr. Zhang's interest, her husband's interest, dominated. We say that was a finding which the judge was entitled to make and would be determinative of the question of consumer. Unless there are any questions, those are our submissions.
Right, thank you very much, Mr. Finch.
I'll take the left hand back. Authorities. Can I just start by handing up, we've got a supplemental authorities bundle. It was filed overnight, but there are only two aspects to it. First, the Advocate General's opinion in the Commission in Spain, and secondly, a copy of a decision that was omitted by accident, the Paywood decision that Mr. Justice Bright referred to when he was giving judgment in this case. You can put them to one side for the time being. I'll refer to them in a moment. I'm going to proceed in relation to the fourth argument that we've heard today from Mr. Lewis on the same basis that I've succeeded on showing the court that Mrs. Zhang was a consumer, that the terms had a sufficiently close connection to the UK, and the term was unfair. So on those bases, I make my submissions. My first submission is simply factual, and it is something I think my learned friend, Mr. Lewis, accepted during the course of his submissions. Mrs. Zhang could not have taken this point under the Consumer Rights Act before the enforcement proceedings in England. It was a Hong Kong arbitration, and in those circumstances, even in determining the arbitrator's own jurisdiction, he would have to apply Hong Kong law, so it wasn't available to her during the course of those proceedings. Now, I'm not suggesting that my learned friend has suggested otherwise, but one of his factual points was that there was an arbitration at which many of these matters were determined. So with that factual basis in mind, can I ask the court to turn to supplementary bundle divider 15? And page 225. I've done that for the simple reason that we've set out in the skeleton argument before the High Court both section 71 and the explanatory notes. So I'll just read the relevant parts of section 71 that I wish to place emphasis upon. Subsection 2 applies to proceedings before a court, so it's not limited in any way, which relate to a term of a consumer contract. The court must consider whether the term is fair, even if none of the parties to the proceedings has raised that issue or indicated that it intends to raise it. In the explanatory notes, it is stated, courts hear a wide variety of disputes between traders and consumers concerning contracts. However, courts are not always specifically asked to look at the fairness of a term in a consumer contract. This provision places a duty upon the courts to look at the fairness of the terms, even if the parties do not specifically ask the court to do so. This section reflects the view, I think that should be CJEU, in Mostaza Claro, that the nature and importance of the public interest, I lay emphasis there, underlying the protection which the directive confers on consumers, justify, moreover, the national court being required to assess of its own motion whether a contractual term is unfair. And so to take my learned friend's last point first, he asked the court to depart from Mostaza Claro on the basis that Article 6.4 of the EU Withdrawal Act permits this court, and I have to accept that, to depart from EU decisions. What it doesn't permit this court to do is depart from a statutory provision that represents the will of Parliament. There are several points I wish to make in terms of statutory construction. The first is the consequence of a term being unfair is that it's not binding on the consumer. That's not a discretion, that's the application of the provision. And so I think the point was made during the course of my learned friend's submissions. If this court were to have determined that this was an unfair term, it would be required to say that despite the fact that a statute tells the court that it's not binding on a consumer, it's binding nonetheless. And that cannot be right, we say. Secondly, as a matter of statutory construction, this is an example of lex specialis, a special rule, over the general. Now we say that section 71 and section 1033 are complementary, they're not in conflict. This is precisely the type of provision that represents public policy of the kind that would justify not enforcing an arbitration award. But in any event, just as a matter of statutory construction, we have to consider that the Consumer Rights Act also amended the Arbitration Act. And I've set out I've set that out, forgive me, at 228 in the skeleton argument.
In the one we're looking at now?
Yeah, in the one you're looking at now, a small Roman C at the top of the page. As a matter of construction, Parliament must be presumed to be aware of relevant pre-existing law, both statute and common law. When enacting Section 71, the Consumer Rights Act made specific amendments to Sections 89 to 91 of the Arbitration Act 1996 in relation to unfair terms. And that's the rule that requiring an arbitration or requiring a consumer to submit to arbitration for less than £5,000 is an unfair term. And so our submission is that the relationship between the lex specialis, Section 71, and the general rule in Section 103 must be presumed to have been considered, and the fact that there are no express provisions disapplying Section 71 in the context of the important policy principle of New York arbitrations, which we accept, is an indicator of its importance. Indeed, it would be difficult to see how it could have been otherwise, given that it was a matter at the time of mandatory EU law. And so, if there had been a dilution of the principle as set out in Claro, then that would, in all likelihood, have been contrary to EU law. Can I then turn to Claro, which is at Divider 21, at page 467 in the hard copy. I'm afraid I've not kept up with where we've got to in the electronic version. Both Claro and Astacom, which I'm going to come to in a moment, are decisions in which there had been an arbitration where unfair terms had not been considered. In Claro, the consumer appealed against the decision within the procedural framework of the national court. In Astacom, the consumer didn't. And we'll come to what that means, what we say that means in terms of effectiveness and equivalence in a moment. But I'd ask the court to just turn to paragraphs 33 to 34 in the judgment. And it's the submission that was made by the trader and the German government that if the national court were allowed to determine whether an arbitration agreement is void, where the consumer did not raise such an objection during the arbitration proceedings, this would seriously undermine the effectiveness of arbitration awards. That is essentially the argument that my learned friend advances. It follows from that argument that it's in the interest of efficient arbitration proceedings that review of arbitrations awards should be limited in scope, and that annulment of or refusal to recognise an award should be possible only in exceptional circumstances. But at 38, and this is the key provision, which I think the court is already aware of, the nature and importance of the public interest underlying the protection which the directive confers on consumers justify, moreover, the national court being required to assess of its own motion whether a contractual term is unfair, compensating in this way for the imbalance which exists between the consumer and the seller or supplier. And it's that express policy that is referred to in the explanatory notes of section 71. And the fact of Brexit, in our submission, does not alter Parliament's intention when enacting that provision. It was expressly stated to follow that. Now, the point that my learned friends makes in relation to Astecom can be illustrated perhaps by my submission yesterday that section 71 should apply to this court, to which your lordship responded, well, that would rather avoid having to get permission, wouldn't it, in relation to this appeal. And it's a reflection, Astecom, of the principle of in conflicts of law that the rules of court procedure are to be taken to be those of the country with jurisdiction, the lex fori. As a general conflicts principle, procedural rules are those of the court with jurisdiction. And equivalence and effectiveness here, in the Astecom case, was not about any equivalence between rights or any contrast between the right or the interest in finality and the consumer right in relation to unfair terms. It simply that the EU, what the EU was saying was that in relation to EU rights, a consumer should have the same procedural rights in his member state as he would for other rights. And it's the equivalence of access through procedural law to rights that the case was concerned with. Essentially, in that case, if the consumer had challenged the arbitration award within the 60 days, that was the Spanish law, procedural law for such challenges, the same result would have been arrived at as was in Claro, because the principle they re-enunciated the principle in Claro. It was because there had been a failure to comply with domestic procedural rules that a different result was arrived at. And that makes complete common sense in the context of EU law, which generally doesn't regulate the procedures of member states because they are often different, because there are civil jurisdiction systems, there are common law systems, and there are combinations of the two. And so what we say this case provides is not an example of how you would compare the right under section 71 to the right to the interest in finality in arbitration awards. That's not the interest that they were talking about. It's the procedural right to bring proceedings. And the passage that my learned friend relied upon, we say he has misread. And so I need to turn to Astecom now, which is at divider 30.
31.
Sorry.
31.
31 blind. And it's at 52. It was a passage that was read to you. Paragraph 52, page 850 in the hard copy.
Yep.
Accordingly, in the view of the nature and importance of the public interest underlying the protection which the Unfair Terms Directive confers on consumers, Article 6 of the directive must be regarded as a provision of equal standing to national rules which rank within the domestic legal system as rules of public policy. So what it's saying is not that you compare and balance one right against the other. It's saying this consumer law right has the same status as another public policy right that would justify departure from arbitration an arbitration award might. And that can be seen from paragraph 59. In the light of the foregoing considerations, the answer to the question referred is that the Unfair Terms Directive must be interpreted as meaning that a national court or tribunal hearing an action for enforcement of an arbitration award, which has become final and was made in the absence of the consumer, is required, where it has available to it the legal and factual elements necessary for that task, to assess of its own motion whether an arbitration clause in a contract concluded between a seller or supplier and a consumer is unfair, insofar as, under national rules of procedure, it can carry out such an assessment in similar actions of a domestic nature. And so what we are saying about Section 71 is that a consumer can raise the argument, but within the English court's processes and procedures. It would not be open to a consumer to simply come back, say in this case or another, in 5 years' time and say, because of Section 71, you've got to consider my consumer rights. That's only within the domestic framework of court procedures.
These were domestic Spanish arbitrations, not New York Convention arbitrations.
Yes.
They show, it seems, that consumer protection is sufficiently important to qualify as public policy, but Section 103 of the Arbitration Act only says that refusal of enforcement may occur where there is where it would be contrary to public policy. So what is it, on your case, in the consumer protection context, that converts may to must in a consumer protection case? Is it Section 61 of the? So I mean 62. Do I?
62. Yes.
Of the 2015 Act, or is it something else?
It's Section 62.
So it simply comes back to that.
It absolutely comes back to the fact that for a court not to do that, it would have to avoid the consequence of a statute that is designed to apply in circumstances where a consumer rights have not been considered. That's the key to it. It's not every mandatory provision. It's that this provision applies where, contrary to in circumstances where the Henderson and Henderson principle would otherwise prevent it. So
in the consumer case, once you jump through all the hoops of being a consumer, an unfair term, and so forth, inevitably the enforcement of the award must be refused.
Yes, and what I'd say about this provision, it's quite unusual. There aren't very many provisions of its kind. The only provisions I can think of, and we were trying to look for them over the short adjournment, the only other kind of supervening statutory provision is human rights. But
Sorry, you're talking about Section 71.
yes, I mean it's a very unusual provision in the context even of consumer law, but it's there and it must be taken to have been intended to be enacted in the same way that the European law was set out in Claro. Can I give the court some comfort by turning to my final submission? I've got a few cases that I don't need to take the court to, but I will set out at the end. But it's the report of the International Law Association on Enforcement in 2002. That can be found in the second authorities bundle, divider 54, and I'm going to start with page 1436. And
So 1.4 which?
1436 started the first page.
Oh, yes.
Recommendations. These are the recommendations. I am told, I don't know, I have to say that the International Law Association is a reputable and well-regarded body that met to make recommendations in relation to New York Convention arbitration awards. And it's the second paragraph. First of all, an enforcement court must carry out a balancing exercise between finality and justice.
Sorry, where are you reading from?
1436, the second paragraph down. The finality of award.
Oh, yes, yes. Thank you.
The New York Convention and the model law permit such an exercise by making the court's power discretionary. Enforcement may be refused. And there's reference to the Eco-Swiss case there, and in particular the exceptional circumstances that justify departure. Now, because Claro and Astacom are not New York Convention cases, and indeed that's unsurprising given the context, the consumer context. Claro, the primary basis upon which Claro was determined was following Eco-Swiss. Eco-Swiss was a competition case where the CJEU disapplied a Netherlands arbitration, New York Convention arbitration award on the basis of competition grounds. But the point I make is that it's not important, we say, that the arbitration awards in Claro and Astacom were not New York Convention awards. It's the principle of arbitration, and that is set out there underneath the passage I've just referred to. So the next part of this document I'd ask you look at is at the bottom, the penultimate in bold paragraph, recommendation 1B. Such exceptional circumstances may in particular be found to exist if recognition or enforcement of the international arbitral award would be against international public policy. International public policy is not the policy as between states. It can be, but it's made up, if we turn to 1441, it's comprised of three elements. Recommendation 1D, the international public policy of any state includes fundamental principles pertaining to justice or morality that the state wishes to protect, even when it's not directly concerned, rules designed to serve the essential political, social, or economic interests of the state, these being known as the loi de police. I did look at what that was in French. It's laws of the police, so it didn't help me very much, but or public policy rules. And 3, the duty of the state to respect its obligations towards other states or international organisations, so what we would conventionally consider to be international law. International public policy can be broken down into those 3 categories. And then recommendation 1E says this: an example of a substantive fundamental principle is prohibition of abuse of rights. An example of a procedural fundamental principle is the requirement that tribunals be impartial. An example of a public policy rule is an antitrust rule. An example of an international obligation is a United Nations resolution imposing sanctions. Some rules, such as those prohibiting corruption, fall into more than one category. And then it's the final paragraph on that page that I draw the court's attention to. An example of public policy rule is an antitrust law, including in particular EU competition law, Article 8.1 of the European Community Treaty. Other examples are often cited are currency controls, price fixing rules, environmental protection laws, measures of embargo, blockade or boycott, tax laws, and laws to protect parties presumed to be in an inferior bargaining position, for example, consumer protection laws. And so the point we make about that is it's long been understood by the international arbitration community that rules protecting rights, particularly important rules protecting UK consumers, it's in the unusual situation that I can say that every single person is protected by those rights who sits in this room, that we say that this is a good reason why the important principle of finality in arbitrations can, on occasions and exceptionally, be departed from. I mentioned that I was going to refer to certain other cases. I won't take the court to them, but passages in support of the importance of that policy can be found in the judgment of Lord Justice Burse in Soleimani. The relevant paragraph is 151. It's found in the Authorities Bundle Divider 51. And also in the treatment by the High Court in the Alexander Brothers case by Mrs. Justice Cockerill at paragraphs 180 to 183, and that's found at Divider 47. So then that finally brings me on to this case and to the judgment of Mr. Justice Bright, but not in our case, in the case he refers to Hayward. And that can be found in the Supplemental Authorities Bundle. And Divider 2, page 44. He first cites a passage from Alexander Brothers, from Mrs. Justice Cockerill, citing the general principles in the IPCO case that my friend referred to. Public policy, as referred to in section 103.3 of the Arbitration Act, means the public policy of England and Wales, as the country which enforcement is sought, in maintaining the fair and orderly administration of justice. This classic formulation as to what is seen as contrary to public policy is contrary to the fundamental conceptions of morality and justice. And our submission is that consumer rights fall squarely within that concept. He then goes on to give 4 reasons why the Consumer Rights Act should be considered in that context. Paragraph 104. He sets out the basis of the Consumer Rights Act, and then at 105, there can be no dispute that the directive represents public policy. This has been authoritatively established in Claro and Astacom. In Astacom, it was confirmed in the context of a final arbitration award that Claro was authority for the proposition that consumer protection, as regard the fairness of contractual terms, had equal standing to national rules which rank within the domestic legal system as rules of public policy. Number 2, at 108, the fact that the Consumer Rights Act 2015 is a UK statute rather than a mere English statute arguably underlines its general significance in policy terms. This also means that it expresses the policy of the United Kingdom as a whole. 3, at 110, the fact that the court is obliged to consider the fairness of consumer contract terms, even if not raised by the parties, reinforces the importance of this as a public policy. And then 4 at 113, given the relationship between section 74.1 and article 6.2 of the directive, and in light of the Mostasa, Claro and Astacom, it follows that I'm obliged to treat section 74.1 as an expression of UK public policy. And finally, at 117, this isn't a new reason. It repeats, this must be treated as an expression of UK public policy in the light of Mustazo Claro and Astacom because it enacts the directive. Once again, this is a conclusion I would have come to in any event. Those are the submissions I have in relation to that point. I don't intend to reply in relation to the other points, save for one matter, which can be found in the opinion of Advocate General Bielhode, which is at divider 1. And the paragraph that I'd ask the court to turn to is paragraph 27. This is in relation to the submission made in relation to close connection. It was with some serendipity. I read paragraph 27, which reads, I think that is indeed the case. The criterion in the directive of a close connection between the contract and a member state may be satisfied in a variety of ways. There is thus a low threshold for activation of the protective effect of the directive, where the parties to a contract have opted for it to be governed by the law of a non-member country. And to the extent that that is reflected in the judgment, my submission that close connection here should mean a connection that is not distant or remote seems to echo the sentiments expressed in paragraph 27. Well, might I just take a moment? Unless your Lordship really have any questions, there's no submissions.
No, thank you very much indeed. I think, Mr. Lewis, you're entitled to say something about Paywood and the Advocate General's opinion, if you want to.
We were hoping to reply a little more on grounds 3 and 4, subject to the court.
Do you have a, I mean, it's not a cross appeal, do you have a reply?
In the timetable we did, but if the court doesn't wish to hear from us further, then of course.
How long do you want to be?
My Lord, I had 5 very short points, which might take 5 minutes.
A minute each?
I'll do my best, my Lord. My Lord, 5 points in response to my learned friend, Mr. Finch, on ground 3. First, it was said that we have to show that Mrs. Zhang had sufficient connection with Chong Sing to make providing the guarantee being in the furthering of her business. We say that's not right, and that's not the test in Tarkow. I say that for this reason. If the guarantor had to be furthering, or simply furthering their business purposes, they would already be caught by the acting wholly or mainly for purposes related to their business wording. So we do say that the Tarkow test goes a little further. My second point is that my learned friend said that the Tarkow test is there to catch the likes of Mr. Zhang. Now, we don't accept that at all. On the facts of this case, Mr. Zhang was the controlling and managing party in Chong Sing. That's in the judgment at paragraph 4, Rome 3. So again, it's obvious that his guarantee was given for the purpose of his profession, and falls naturally within the language of 2.3 without the need for the functional link test. So again, we do say that this is not the sort of situation which Tarkow, Mr. Zhang is not the sort of situation that Tarkow was intending to encompass. Thirdly, it's said that the familial shareholding did not give Mrs. Zhang any control over Chong Sing. There are 2 points in response to that. Firstly, control over the business is not the test. And secondly, in any event, that submission ignores the reason why the familial shareholding is recorded as being that of Mrs. Zhang. Family members are considered to be persons who are in a position to control the shares. That's the express purpose of listing shares in this way in a publicly listed company under the Securities and Futures Ordinance. And the same approach is taken in this jurisdiction with the test under the Financial Services and Markets Authority and the test for connected persons. My fourth point is that my learned friend says, well, at its highest, in my case, at its highest, the fact that the words wholly or mainly are used means that if there was both a business motive and a personal marriage motive, unless the business motive dominates, she will still be a consumer. But we say that that submission exemplifies the error in my learned friend's reasoning, and indeed in the judge's reasoning. It is not permissible to substitute the word motives for the objective test of purposes of the contract. And as I said in my submissions, my learned friend is trying to urge you to look at the transaction simply through the narrow lens of what Mrs. Zhang was thinking about at the time, and that's not the objective test. My fifth and final point, I think getting in within my 5 minutes, is that if my learned friend is right, that subjective motivation is the touchstone, we'll consider this. What if on the same facts, Mrs. Zhang didn't love her husband and didn't always do what she was asked, but Mr. Zhang asked her, because she was one of the majority shareholding couple, and that's what Eternity Sky wanted, Mr. Zhang asked her to consider providing the guarantee. Mrs. Zhang did her homework and thought, yes, actually I think this is a good thing. Chongqing needs this influx of the cash, and therefore I'm prepared to give the guarantee. On my learned friend's case, and on the judge's test, she would not be a consumer because she wants to further her financial interest in the company and has no interest in marital duty. Yet objectively, there is no difference between the two scenarios. The transaction is the same, the aim of it is the same, and its nature is the same. So we do say that example demonstrates why subjective motivation cannot be a relevant factor. Lords, my lady, those are submissions in reply.
Thank you very much.
2 very short points on ground 4, if I may. Just to draw the court's attention, firstly, to the Attorney General in Asturcom, where he said the res judicata principle should be disregarded, and the court did not go that far. And secondly, Eco-Swiss is also not a New York Convention case; it's an annulment case.
Yes.
Can I?
Well, I think we've had enough to it, really.
Yeah. I was going to simply refer. It may not be a New York Convention case, and I may be right about that, but they do refer to the New York Convention principles in the judgment when they're enunciating the principle.
Yes. Well, you waited patiently, Mr. Riley-Smith. Thank you for your written submissions, which we appreciate.
Very grateful.
I don't know what, if any, questions we have for you, but you've heard a lot of submissions covering a lot of points. So if the CMA has points which you would like in the public interest to draw to our attention, we would, I think, be grateful.
I'd be incredibly grateful. Thank you. First of all, may I say how grateful we are that we were permitted to intervene in the first place. We do so in the public interest from a perspective as a consumer protection enforcement authority. We are neutral as to the outcome of this appeal. We don't enter into the fray, but the court has been asked to construe and apply a number of statutory definitions that lie at the very heart of the Consumer Rights Act and the consumer protection regime in this country, against a rather unusual factual background. But that's often the way in the higher courts, for obvious reasons.
It'll be the non-typical cases which reach the higher courts.
And your decision is likely to have a significant effect, therefore, on the law that the CMA has to apply on a daily basis. And that's why we're here. We appreciate that you've been addressed with great care, great skill by others, and we are not here to duplicate submissions that have already been made. It's not our role to do that. And so we simply wish to offer a few focused thoughts on 4 issues, if I may. However, I know I have limited time. I asked for limited time, and I hope to stick to that limited time. To assist you, I had produced, and please forgive me if this is rather old school, a handwritten annotated skeleton argument with references. For Milady, I have produced a little black file which should be on your desk, which has both the hard copy and the electronic bundle references. And I hope very much that the clerk might be able to pass up to my lords the hand annotated skeleton.
Well, I do remember handing in myself a handwritten skeleton in the very early days of such things.
Not very elegant, bit old school, forgive me, but I hope effective. And the points.
Oh, I thought you meant it was in handwriting.
Oh no, I'm so sorry.
No,
No, I've just annotated the authorities' references. I'm not sure you'll be able to read my handwriting if I produced a skeleton on that basis.
Yes. So this is the document we've already seen, but now
Yes.
with some annotations.
But with referenced, and I hope helpfully. 4 points I wish to make. First, an overarching submission that the unfair terms provisions in the Act should be construed in accordance with the original legislative purpose of the directive. That's my first point in the skeleton. Secondly, briefly to touch on the second point in the skeleton, which is to highlight the fact that definitions of consumer in the Act are different to the directive. Thirdly, to offer brief comment on the submissions made by Ms Morgan in relation to evidence of intention and its relevance. And finally, to offer a couple of thoughts on the debate yesterday as to your approach to the average consumer test.
Yes.
First point, dominant purpose of the directive is a high level of consumer protection. I'm very grateful for the indication that you have my written submissions and have read them. I simply wanted to take you to an important document within your bundle which you may not have had an opportunity to see. It is at Divider 50, Authorities Bundle Divider 57, page 1782, and it's the Commission Notice. The unfair terms provisions of law in Part 2 are derived, of course, from the directive, and guidance on the purposes behind the directive is provided in this Commission Notice. They're set out, as I said, on page 1786 in the hard copy, E1763. There's a helpful heading, the objectives of the UCTD at the bottom of the page.
May I just ask, what is the status of this guidance in interpreting?
It is Commission Notice. It is therefore Commission Guidance. It does not obviously bind. It is intended to assist. And that so much is made clear at the top of page 1784. In the third paragraph, which is the purpose of this guidance notice, is to present in a structured way the interpretation which the CJEU has provided on the key concepts and provisions of the UCTD.
So a bit like a textbook, really.
Yes, and in a case called Purely Creative, a wee while ago, Mr. Justice Briggs very helpfully, and forgive me, it's not in the bundle.
Sorry,
Right.
what was the reference for that statement?
It is
1784.
1784 in the hard copy,
Yeah,
so that would be 1761 electronic.
thank you.
Third paragraph down,
Thanks.
the main purpose of this guidance note. And my lord, in answer to your question, in a case called OFT and Purely Creative, Mr. Justice Briggs highlighted that courts can obtain assistance from, but are not bound by, guidance from the Commission. And I can provide the court with a copy of that authority. For what it's worth, it's paragraph 40, and the reference is 2011 EWHC 106. So I hope that it would provide assistance to the court in construction, but of course it takes no further than that, and akin to a textbook.
Did you say paragraph 140?
40, just
40.
no one beforehand.
Thank you.
Back to the bottom of page 1786, hard copy, 1763 electronic, the objectives of the UCTD. Over the page, the top, it reads as follows: therefore, the UCTD has a double objective. The effective protection of consumers as the typically weaker party against unfair contract terms which are used by sellers or suppliers and have not been individually negotiated, and contributing to the establishment of the internal market with a minimum harmonisation of the national rules aiming at this protection. It then sets out a quote from cases in your bundle in the box. I won't read it out for time, but below that box are the words "in that connection." I'd ask you to highlight that paragraph. In that connection, the court has repeatedly qualified protection under the UCD as a matter of public interest. as expressed in Article 114 of the Treaty on the Functioning of the EU, the legal basis for the UCTD, as well as in Article 169, etc., the UCTD provides for a high level of consumer protection. And if my lords and my lady were to look at the footnote, footnote 14, which is referenced there, you will see the words, at the time of adoption, Article 100A of the treaty establishing the European Economic Community. And for your notes, I need, in your authorities bundle at tab 2, page 8, is Article 100A. And 100A3 is the relevant one, which specifies that a high level of consumer protection should be afforded in, or that provisions that are brought in for consumer protection purposes should confer a high level of protection. But back to the Commission notice, I also would ask you to highlight the words that follow just thereafter. According to the settled case law of the court, the system of protection introduced by the directive is based on, then in the box, the idea that the consumer is in a weak position vis-à-vis the seller or supplier as regards both his bargaining power and his level of knowledge, which leads to the consumer agreeing to terms drawn up in advance by the seller or supplier without being able to influence the content of those terms. Reading on, the UCTD thus aims to address situations of inequality of the parties in relation to contract terms, which can be due to an asymmetry of information or expertise or bargaining power in relation to the contract term. In particular, through the non-binding character of unfair contract terms under Article 6, one of the UCTD aims to create an effective balance between the parties under the contract by removing the imbalance created by unfair contract terms in order to compensate for the weaker position of consumers. And finally, the last paragraph aims to deter sellers or suppliers from using unfair terms in the future. So, my lords, my lady, those are said to be by the Commission, on analysis of the CJEU case law, a nice summary of the objectives of the directive. And if I can ask you to turn back to the written submissions that I made and just highlight paragraph 8, how a recent judgment has summarised the effect of an analysis of that case law and also of that particular document, the Commission notice. I refer there to the judgment handed down recently by Daniel Alexander, King's Counsel, sitting as a Deputy High Court judge, in a case called Oxford University Innovation Limited and Oxford Nano Imaging Limited. And at paragraph 237, and I've set out the whole quote, the relevant part of the quote in my written submissions, he says this: "This also suggests that where a question arises as to whether a consumer should be entitled to protection, it may be appropriate to lean towards the approach which provides a higher rather than a lower level of consumer protection, including as to whether a person is to be regarded as a consumer at all." And we adopt that sentiment.
I can see that as a general proposition. Do you have any submission as to the way in which that principle would be applied to the various issues which you've heard submissions being made about?
I will be making general submissions, trying not to enter into.
Well, I know you don't want to enter into the fray.
About the definition of consumer, but it will be, I'm afraid, a general submission. But my submissions all my submissions are effectively affected by the general approach in the directive, and they encourage, and my submission is that the court should bear that in mind when considering the construction of the various terms under the 2015 Act. And if and insofar as the court is able to give effect to those policy objectives, legislative objectives, within the construction of a particular term, in my submission it should do so. And my Lord, therefore, as I said, paragraph 10, we respectfully submit the court should bear in mind that the directive treats consumers as presumptively weaker parties, and therefore in need of protection from abuses by stronger contracting parties. And the purpose of the legislation is to confer this high level of protection. And I have set out what Lord Justice Laws said some time ago in a case called the London Borough of Newark and Catton, and I know I won't read it out, it's in my written submissions, and I hope the point is there.
Yes?
And finally, my Lord, we say that this point was recognised recently in the Court of Session, for what it's worth, in a case called King and Blackhorse. That, for your note, is that Authorities Bundle, tab 53, page 1432, hard copy, which is 1419 electronic, and paragraph 36. Lady Dorey and the Lord Justice Clerk says that there, the starting point for an exercise of statute construction must be the words of the statute itself, and where the statute was enacted pursuant to European directive, the policy and words of the directive. Now, it was about a different directive, but the principle remains the same. My Lord, with that in mind, may I turn to my second point, which is the CRA's definition of consumer being broader than that in the directive.
Yes.
And my Lord, it's a very simple point, and as I said, I don't want to enter into the specifics of this case. Please forgive me for that. But when considering whether someone is acting as a consumer, the judge in this case relied on the European case law to which have been taken, Turkow and Dumitras. The former was said to provide the test for whether a guarantor providing a personal guarantee in support of a company is a consumer within the meaning of the 93 directive, and the latter simply confirmed, as you've been shown, the test in Turkow. And the judge applied those authorities when deciding on the appropriate test in this case. And our simple point is that the test in those two cases appears to be formulated simply on the basis of the directive and the wording of the directive. And the wording of the directive is, of course, different to the wording of the Consumer Rights Act 2015. And I've set out the competing wordings in paragraphs 12 and 16 of my written submissions, which you can see that the words wholly or mainly appear in the 2015 Act, whereas they don't appear in the directive. And that definition, as I hope I've explained in the written submissions, is broader because it reflects policy inspired by a Law Commission report from 2012, which recommended the broadening of the definition of consumer. And my simple submission is that when approaching this issue, the court may wish to bear in mind that the wording of the directive in those cases is narrower than the wording of the Act that you are having to apply. And the court may think its construction of the word consumer should therefore be more generous than in the European cases. And this would be consistent with the dominant legislative purpose to which I took you a few moments ago. Ms. Morgan made 2 points in her submissions. One is that she says that the new wording was really intended to apply simply to dual-purpose contracts. And she's right to say that the Law Commission report was looking at dual-purpose contracts. You can see that in the heading in the Law Commission section. But the wording is the wording. And the wording in section 2 includes the words wholly or mainly. And it's not the only legislation in which that wording is applied to follow this policy. I hope you have seen the references at footnote 11 in my written submissions to 2 instruments. There's the Consumer Insurance Disclosure Representations Act 2012 and the Consumer Rights Payment Surcharges Regulations 2012, both of which I hope you've got handwritten references to in the written submissions. And both of those pieces of legislation contain similar definitions of consumer.
I'm not sure we have, actually.
Oh, forgive me. In that case, the Act is at tab 7, page 83, and the regulations are at tab 8, page 85.
Thank you very much.
And you might also be assisted by the commentary in Chitty at 41048, which you will find at tab 58, page 1887 in the hard copy bundle, 1864 in the electronic. Unless there are any questions, I move to my third point,
Yes, thank you.
which is the submissions, it is addressed in the written submissions, reliance on evidence of intention. I'm afraid I lammed in here, unbidden, without by your leave by anybody, noticing that this had not been addressed in the skeleton arguments, but had been addressed below. I hope the court forgives me for doing that. But our submission is set out at paragraph 34 of our skeleton. The court will, of course, bear in mind, as Mr. Fincher said already, that it's for the trader to prove whether someone is not a consumer. But Ms. Morgan's absolutely right. The definition is objective. It's our submission that the court must take into account all the evidence, and that evidence may include evidence of intention. It is not excluded. That's our position. And those submissions are based upon, first, the most recent CJEU authority that summarises this position, which is a French case called, or a case called Pouvin. I hope I've pronounced it correctly. This is at paragraph 29 in our written submissions, where we've summarised the facts and set out, I'm afraid extensively, over 3 paragraphs, the relevant passages from the judgment, which confirm the approach that I've just outlined to your lordships and your ladyship. And also, it's consistent with the most recent domestic case, albeit at first instance, in which this has been considered. Again, it's Daniel Alexander, King's Counsel, in the Oxford University case. And the passage that I found most helpful and I thought might assist the court, I've set out in full at paragraph 30, where Mr. Alexander, and if you open the judgment, you'll see it is it's a testament to industry.
It is enormous judgment.
Enormous judgment, and he has covered everything, and it is now used. Well, I'm using it as almost as a casebook.
Down to the counsel in the case.
And I know that Mr. Finch, who was counsel in the case, was instrumental in ensuring that all points were covered. Anyway,
Well, he'll be wanting some royalties from it.
Paragraph 329 is a very helpful summary of the approach or of analysis of the case law on this issue, and it is that on which I principally based our submissions. And we respectfully endorse his summary at paragraph 29. He refers both to the case of Heffer and the case of Ang, which were referred to by Miss Morgan. And she criticised reliance on both of those cases on the basis that there is limited recitation of the evidence in what were both pretty long judgments. And she says, look, there is no evidence of any intention, so you can't really rely upon those cases in support of this proposition. In Ang, which is the Bitcoin case, Miss Ang invested money. Her partner was a Bitcoin cryptocurrency whiz, it seems. For the purposes of jurisdiction, there was an argument as to whether she was a consumer or not. And the judge summarised the evidence at paragraphs 14 to 17, which is at page 1179 in your bundle, for what it's worth. And in that evidence, he found for a number of things. He found that she'd opened the account to invest personal funds. That's at paragraph 14. He'd found that her activity was that of an individual playing some of her money in the hope of making a large investment gain. That was another one of his findings, paragraph 16. But he sets out his findings at paragraph 58, and they're based upon, his conclusions rather, at paragraph 58, based on those findings. And if you were to look at paragraphs 62 and 63, you see he refers in terms to what she was doing in the hope of doing this, in the hope of doing that. Now, I agree with Ms. Morgan that there is no recitation of evidence of intention in the course of in the judgment, but the findings that the judge makes at least go to intention and reflect the evidence that he clearly felt he had about the hope that Miss Ang experienced in the course of the events that led to this case. Now,
well, I mean, it stands to reason, really, doesn't it, in that kind of investment, that somebody who invests does so in the hope of making a profit. You don't really need to get evidence from them.
So, Ms.
And
Morgan,
you can also describe that as the objective rather than the motivation for it to do something. It seems to me there's a potential difference.
and
And if purpose means the objective, what are you seeking to secure, that is potentially different from the motivation that made you sign a piece of paper.
so I didn't want to disagree with Ms. Morgan in relation to her submissions, which were there is no record of any, as I understand it, intention, evidence of intention in the judgment. But the findings of fact are about intention, and the conclusions relate to intention, as one would expect when one is looking at the purposes, because that's the test.
Right?
And finally, my lord, my fourth point on the average consumer test, because there was a debate yesterday about the proper approach to the statutory concept of the average consumer within the context, it feels like an age ago now, in the context of the debate over sections 64 and the transparency test. By way of recap, if a term lacks transparency, then section 64.2 provides it may be assessed for fairness, even if it might otherwise be exempt. And section 64.3 provides that a term is transparent if it is expressed in plain and intelligible language. Transparency goes further than simple grammatical intelligibility. It includes a requirement for a trader to take sufficient steps to explain the term and bring the consequences to the consumer's attention. That I take from section 68, which you were taking yesterday, which imposes requirements on traders to provide that sort of information. Now, although the Act doesn't say so, European case law, I agree, has established that for a term to be transparent, it has to be intelligible to the average consumer. And I take that from a case called Kasler. For your note, it's at AB 33, page 903, paragraph 74. The average consumer is, of course, defined in the Act. A consumer who is reasonably well informed, observant, and circumspect. So such an average consumer is therefore both reasonably intelligent and reasonably careful when considering a term. That's what the court has to assume. But the reasonably qualification reflects the practical reality that consumers are not expected to be paragons of good sense and virtue, because we are human. And the standard must not be taken so high that real consumers generally are not protected. Because, of course, the purpose, to go back to where I started, behind consumer protection legislation is to give a high level of protection to those who are asked to sign up to standard terms by traders. It's common ground that the average consumer test is an objective one, and the particular characteristics of the consumer in question are irrelevant. But the question arises, as you were debating yesterday, how this test can be applied in practice, and in particular, how far the court should take into account the characteristics of the relevant transaction in which the consumer is being engaged. And you'll recall yesterday you were taken to Mr. Justice Kitchen's judgment in OFT and Ashbourne, in which he considered that the type of contract or transaction in question should affect the court's assessment of the characteristics of the relevant average consumer. And for your note, at paragraph 128, you were taken to this yesterday. This is at Authorities Bundle, tab 26, page 630. In the e-bundle, at 607. He said this: the standard is a variable one and must, I believe, take colour from the context. For example, consumers who are financially sophisticated may be expected to bring to bear a greater understanding of the meaning and implications of the terms of a contract than consumers who are vulnerable as a result of their naivety or credulity. Now, in our submission, that appears to be importation of subjective characteristics, not an objective assessment. And so we wouldn't recommend that wording or that approach to you. But both parties appear to rely upon a later passage in his judgment, to which your lordship went yesterday, paragraph 155, which you'll recall is the one about the gym club. Mm-hmm. He says the question whether a particular term is expressed in plain, intelligible language must be considered from the perspective of an average consumer. Here, such a consumer is a member of the public interested in using a gym club, which is not a high-end facility, and who may be attracted by the relatively low monthly subscriptions. And your lordship was interested in that analysis and that approach because it focused on the nature of the transaction, and that's what both parties are asking you to do. Because Mr. Kirk suggests that the relevant formula, I hope I get this right, is the reasonably well-informed family member asked to sign a personal guarantee for purposes of another family member's business. That was his formula. Mr. Lewis's formula, again, focusing on the transaction, was someone giving a personal guarantee ancillary to a Hong Kong bond issued by a Hong Kong company, I think worth 500 million Hong Kong dollars, which he himself described, I think, very accurately as a rather unusual and perhaps a narrow class of person. The difference between those two formulations appears to be the amount of detail, the granularity of the description of the transaction. And we don't step into the arena, but wanted to offer a couple of short observations on the correct, we suggest, the correct approach to that task. Because we respectfully suggest that the court should be cautious about the level of detail with which it characterises the transaction for this purpose. It is human nature to want to define something precisely, particularly perhaps the human nature of lawyers. And the court and the parties are tempted, I'm sure, to want to define the transaction as accurately as they can in order to understand its characteristics for this purpose. But we suggest that too much granularity or too much precision in defining a relevant transaction could be counterproductive. And that's because the greater the level of detail that the court goes into in defining the transaction question, the more likely it is that the average consumer test will look as though, or the average consumer identified will look like the individual consumer in that case. And the danger is if you go into too much detail in relation to the transaction, that the notional average consumer may begin to morph into the individual consumer in that case. And if you think about the example that Maloney from Mr. Lewis gave, it was very specific about the facts of this case. And it's an unusual...
Well, his description is very specific, so that the average consumer is basically a class of one. On the other hand, Mr. Kirk's description would encompass transactions very, very different from what the parties in this case were actually doing. I don't know whether, without taking sides, you can give any assistance about how we deal with that problem.
Well, my submissions I was going to make, treading very carefully between the warring factions, were to offer these thoughts, that the greater the specificity, the greater the granularity, the narrower or more unusual the subclass, the more the characteristics of the average consumer are likely to have high level of particular knowledge or sophistication about that particular transaction. And the more difficult it is for a judge to ignore the individual circumstances of the facts of the case before him or her, and the more danger, therefore, that the subjective elements that are specifically forbidden by the statute could be imported into that analysis or assessment of the characteristics of the average consumer. It's therefore no longer an objective standard, but it begins to take on the characteristics of either a single person or a very small group of people. And we respectfully suggest that the court should assess the characteristics of the average consumer by reference to the broad type of transaction and not descend into too much granular detail for those reasons. And you then say, but as you have, I understand, my lord, a minute ago, but one has to look at the transaction itself, doesn't one, in order to try and understand how to define the average consumer. But there is another policy at play here, which is the high level of consumer protection, which is where I started and where I finish. And a higher level of consumer protection is conferred if one assumes a lower level of granularity, a lower level of, therefore, sophistication and familiarity with that particular transaction. And in my submission, that would be consistent. That approach, therefore, has the benefit of being consistent with that policy objective. And I can see a brow furrowing to the left of the bench, to my left.
They don't read anything into that.
And so my submission is that what one loses on the swings section, one makes on the roundabouts from the consumer protection perspective, because a lower level of specificity would broaden the group of average consumers. It would mean that the court would not assume that they were imbued with particular understanding of a transaction, which would very probably flow from a very small, unusually small class. And therefore the level of consumer protection would be higher because the average consumer test is more broadly spread across the population as a whole. I hope that makes sense.
Yes.
It may make, whether it's accepted or not, another matter, but I hope that it makes sense as a matter of logic. And when one applies it to section 64, of course, just to bring us right back, and this is my final point, what the court is engaged in section 64 is looking at the average consumer's understanding of the terms that are before her or him. Their transparency, their intelligibility. And that is the task that the court is looking at in section 64. And in our submission, there would be a danger if you were to assume that the average consumer was particularly sophisticated and was someone who was liable to go off and investigate, as the thing was being suggested at one stage during submissions, should be asking questions, should be taking particular steps to interrogate or investigate the terms of the contract. That steps beyond what is required by section 64. Section 64 requires the court to look at the intelligibility of the terms in the contract by reference to the average consumer, who is someone who is reasonably well informed, reasonably intelligent, reasonably circumspect.
Section 64 only refers to the average consumer as being relevant to prominence, but I think the cases have said it also...
Kasler is the one I...
Kasler is
forgive
the one,
me.
is it?
It's my fault for gabbling, but I...
No, it's all right. I remembered I'd seen it somewhere. I couldn't remember which case it
It's
was.
paragraph 74 in Kasler. I hope it'll be on the transcript. It was the authority of the proposition that it also applies to the transparency.
No, it's not controversial. I just couldn't remember what the authority was.
May I just turn my back?
Of course.
My lords, my lady, I'm incredibly grateful. Thank you for hearing me and for allowing us to intervene.
We're grateful to you too, and indeed to all concerned, both the council who've spoken and the team supporting them. We're going to reserve our judgments. They will be circulated when they're ready in the usual way, to give you the opportunity to correct any typos or minor factual errors that there may be. You will all by now be well aware of the limitations on what you can do with those draft judgments, Counsel General for Wales, and all of that. We hope that in the light of whatever we decide in the judgment, you will be able to agree the terms of an order for our approval. If you find that you can't, then we will have short written submissions and make a decision without a further hearing. Thank you all very much. That concludes the appeal.